Be ready for the dictation. Start. Having carefully read the erudite judgment prepared by Brother Chandrachud, I regret my inability to agree that laying an ordinance promulgated by the governor of a state before the state legislature is mandatory under Article 213(2) of the Constitution, and the failure to lay an ordinance before the state legislature results in the ordinance not having the force and effect as a law enacted and would be of no consequence whatsoever. In my opinion, it is not mandatory under Article 213(2) of the Constitution to lay an ordinance before the Legislative Assembly of the state legislature, nor would the failure to do so result in the ordinance not having the force and effect as an enacted law or being of no consequence whatsoever. Further, in my opinion, an ordinance cannot create an enduring or irreversible right in a citizen. Consequently, and with respect, a contrary view expressed by this court in State of Odisha versus Bhupendra Kumar requires to be overruled. In overruling these decisions, I agree with Brother Chandrachud, though my reasons are different. As far as the repromulgation of an ordinance is concerned, I am of opinion that the repromulgation of an ordinance by the governor of a state is not per se a fraud on the Constitution. There could be exigencies requiring the repromulgation of an ordinance. However, repromulgation of an ordinance ought not to be a mechanical exercise, and a responsibility rests on the governor to be satisfied that circumstances exist which render it necessary for him to take immediate action for promulgating or repromulgating an ordinance. Finally, I am of the view that in the absence of any challenge by the employees to the first three ordinances promulgated by the governor of the state of Bihar, their validity must be assumed. Consequently, even though these three ordinances may have been repealed, the employees would be entitled to the benefits under them till they ceased to operate, and the benefits obtained by the employees under these three ordinances are justified. However, these three ordinances do not confer any enduring or irreversible right or benefits on the employees. The promulgation of the fourth and subsequent ordinances has not been adequately justified by the state of Bihar in spite of a specific challenge by the employees, and therefore they were rightly struck down by the High Court. Therefore, I partly agree with Brother Chandrachud on the issue of the validity of the ordinances. The facts relating to these appeals have been detailed by Brother Chandrachud, and it is not necessary to repeat them. All that need be said is that in terms of Article 154 of the Constitution, the executive power of the state shall be vested in the governor of the state and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. In terms of Article 168 of the Constitution, every state shall have a legislature which consists of the governor of the state, and in the case of some states, 2 houses, and in the other states, 1 house. Where there are 2 houses of the legislature, one shall be known as the Legislative Council and the other shall be known as the Legislative Assembly. We are concerned with the state of Bihar, which has 2 houses of the legislature. Article 213 of the Constitution provides that when the governor of the state is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require. However, this is subject to the exception that the governor cannot promulgate an ordinance when both houses of the legislature are in session.